Resigning to avoid a disciplinary hearing. People used to do it in the past, but you can't do it anymore according to the Labour Court. Here's why. My name is Aslam Moolla and I am a registered attorney. Today's video, we're going to be dissecting a standard bank case involving a disciplinary hearing, which was taken to the Labour Court. We did not represent the parties, although we did read about it online and we wanted to bring it to your attention so that you can know better what to do and what not to do in your particular workplace. Let's get started with the facts of the case. In this particular case, the employee was given a notice to attend a disciplinary hearing. What had happened was the employee had actually cashed a cheque without following the proper procedures. It later transpired that the cashed cheque was actually fraudulent, which caused the employer a loss of approximately 30,000 rand. On the day that the employee received a notice for the disciplinary hearing, the employee handed in a letter of resignation, which said that she had done so with immediate effect. The employee was then informed that she would be required to work her notice period and that the disciplinary hearing was to proceed in the notice period. The employee disagreed with that approach and said that the employment relationship had actually ended when she submitted her immediate resignation. In any event, Standard Bank held the disciplinary hearing in her absence. She was found guilty and she was dismissed. I stand to be corrected, but I think her name was also listed on the Reds database. Initially, the Labour Court held that once an employee hands in their resignation, it is done with immediate effect and the employment relationship comes to an end. And essentially, the Labour Court said that the dismissal was null and void, that Standard Bank couldn't do anything about it. Although the decision was taken on appeal to the Labour Appeal Court. And here's what the Labour Appeal Court had to say. The specific words were, the argument that where an employee gives notice of termination by way of resigning with immediate effect, such employee cannot be compelled to continue working for the employer because of the resignation is not true, and the employment contract still continues until the notice period ends. In other words, just because you resign from work, you must still serve your notice period unless the employer waives the notice period, and you don't have to do so. Therefore, the resignation of the employee only takes effect once the notice period has run its course. In other words, an employer is entitled to proceed with a disciplinary hearing during the notice period, irrespective of the date in the resignation letter. Therefore, the Labour Appeal Court has clarified the issue of resignation with immediate effect pending a disciplinary hearing. In summary, a person cannot escape a disciplinary hearing by resigning immediately. The employer still has the power, according to this judgment, to have the disciplinary hearing in the notice period. It's essential, therefore, that you consider and prepare for the disciplinary hearing. You cannot avoid it. If you need help doing so in your situation or taking your case further to the CCMA to clear your name off the Reds database or to clear your name from being tarnished, you're more than welcome to contact our offices. I wish you all the best and I'll speak to you soon.